Okay, we'll go to 9B, adopt the ordinance to amend the Seaside Municipal Code, adding chapter 9.05, prohibiting aggressive solicitation in the city streets, medians, and other places, and amending chapter 9.20, overnight occupancy of vehicles on public property, 9.21, storage of personal property on city property, and 10.32, stopping, standing, parking. The proposed ordinance amendment is not subject to the California Environmental Quality Act pursuant to section 15061B3 of the CEQA guidelines. For the public, this is the second reading of this ordinance, and it has been talked about before. Mr. City Manager.
Yeah, thank you, Mayor. Again, I'm going to call on Dan Mealis, Assistant City Manager.
Good evening again, Honorable Mayor, members of City Council, City Manager and staff. Dan Mealis, Assistant City Manager, and we're here for the second reading to amend these multiple chapters of our city code. So a little bit of background and why it matters to Seaside. We're looking at promoting public health and safety, ensure accessible and safe public spaces for all residents, protect constitutional rights, respond to community concerns regarding unsafe and aggressive solicitation, accumulation of personal property, and overnight vehicle occupancy. So the new chapter 9.05 for aggressive solicitation prohibits unsafe aggressive solicitation in key public spaces. This identifies some of the locations for medians, traffic lanes, financial institutions, driveways, and after dark. And it protects free speech rights with time, place, and manner restrictions. It supports pedestrian traffic and commercial safety. And then we added the definitions for aggressive, which is defined in section 9.05.020. We revised chapter 9.20 for overnight vehicle occupancy, prohibits occupancy in vehicles on public property between the hours of 9 p.m. and 6 a.m. In the current ordinance, it states it's 10 p.m. and 6 a.m., so we're backing it up an hour. This aligns with state and legal standards as well as our neighboring communities. And we're also revising chapter 9.21, which adds some key definitions, which identifies attended versus abandoned property. It outlines what is considered accessible or unlawful storage. And then it also highlights the essential items for survival and that are protected unless deemed unsafe. When we revise chapter 9.21, storage enforcement, prohibits the storage that blocks ADA access or entrances to variety of businesses and doorways and entryways, enables cleanup of public property with 72-hour notices. Personal property may be disposed of after 60 days. And outlines notice, impoundment, and disposal procedures. It also highlights that health and safety risks can trigger immediate removal of these items before those 60 days. We are also revising chapter 10.32, parking, under parking amendments. So it removes the fixed 4-hour limits at 3 of our parks, Catino, Laguna Grande, and Roberts Lake. And the new regulations will allow for the city manager to set the posted signage for any of our city facilities. So the recommendation is to adopt the ordinance and amend Seaside Municipal Code, adding chapter 9.05, prohibiting aggressive solicitation in cities, streets, medians, and other places, and amending chapters 9.20, overnight occupancy of vehicles on public property, 9.21, storage of personal property on city property, and 10.32, stopping, standing, and parking. And with that, I would be happy to answer any questions.
Thank you. Thank you for that fine report. Are there any questions from the council? Councilmember Miller.
Thank you. Thank you, Mr. Mealis. I got a comment today that if this gentleman gave me a hypothetical, and the hypothetical was that if he goes and gets a cheeseburger and sits in his car and eats a cheeseburger after 9 o'clock, is he violating any city code?
Depends on where he would be parked.
So if somebody's not spending the night or overnight in a car, they're just in the car for 20 minutes, maybe this question goes to the city attorney, but if they're in for a short period of time, are they violating this code?
I'll defer to the city attorney.
Through the mayor. Thank you for that question. As I understand your question, if somebody is eating a cheeseburger after 9 PM in one of our parks or other areas that this ordinance applies to, is there a violation? And the answer to that would be yes, because there's no standing, stopping, or parking after the time specified. That is our current law. The only difference here is instead of at 10 PM, we're moving it 1 hour earlier to 9 PM to make it consistent with our internally consistent with our other code sections.
Thank you for that. And just so I understand correctly, the code that we have in our current city code is the same code that we had before that we have tonight. The only difference is that we are moving it up 1 hour from 10 o'clock to 9 o'clock. Is that correct?
That's correct.
And in regards of the aggressive, we've defined aggressive in a way that makes sense.
Yes,
And another part of this code does not allow people to stay in our medians.
that's correct.
And we don't currently have a code for that.
That is correct.
That's all my questions. Thank you, Mr. Mayor.
Anyone else? I got a question because I was a little confused. So the hypothetical was if somebody went and got a hamburger and was eating in their car, would they be violating the code? The eating the hamburger is not the violation, it's being in the park when the park is closed.
That's correct.
Okay, I just want to be clear. I thought it was a good question, but your answer kind of threw me off. It's not about what I would say it's not about what you're doing, because you could be doing something positive or something negative, but if the park is closed, then you shouldn't be in the park. Is that the understanding?
Yes, that's correct.
Okay. All right. I want to make sure I'm understanding what's going on. Thank you so much. We'll take it out to public comment.
So my name is Tim Heaven. I come to you before you today as a humanitarian with lived experience of being unhoused. I'm the chair of the Lived Experience Advisory Directive. I serve on the Continuum of Care Leadership Council, co-chair of the Monitoring Evaluation Committee. I sit on the California State Policy Advisory Committee with Corporate Supportive Housing. I'm a member of the Bring California Home Committee, and I also serve on the board of directors with the Coalition of Homeless Service Providers. I'm an artist and DJ on KHTC 90.9 FM. I share this not to boast, but so that you understand, I speak with both lived experience and personal knowledge, and I stand here as a voice for the voiceless. So I rise tonight to state clearly and without hesitation, I oppose any revisions to this that's happening. I think altogether, it just really needs to be repealed. Just to be clear, it's not just about parks. These ordinances apply to public areas as well. And that means sidewalks, parking lot, streets, the very places people have no choice but to exist when they cannot afford a roof. The only difference in this revision is that instead of making it illegal to rest in a public area at 10, now it becomes 9. This is not progress, this is regression. This is not a solution, it is an even harsher punishment. The ordinance should not be revised, it should be repealed altogether because at its core, it criminalizes poverty. It stigmatizes and stereotypes people forced to sleep in vehicles or on public land as dangerous, as threats to public safety. But that logic is absurd. If simply sleeping makes a person dangerous, then by that standard, everyone sleeping in their own homes would also be a public threat. Should we arrest people in their beds for closing their eyes? Of course not. So what these chapters really do is wage war on the poor. They direct our police to confiscate people's belongings, their IDs, their medicine, their photographs, throw them away, arrest them, jail them, and release them with nothing. That's not leadership. That's cruelty dressed up as law. And Seaside knows better. During COVID, on Colonel Durham, the city opened a safe sleeping site. I lived there. It was stable, calm, and clean. There was one rule, no violence, and it worked. But when COVID ended, that site was closed, not because it failed, but because of an urgent need for development. And nearly 5 years later, the lot still sits empty. Empty ground where compassion once stood. Meanwhile, the cost of rent in Seaside and across California has become simply outrageous. Never in history has there been such a disproportion between what people earn and what they must pay in rent. I have led homeless outreach in this county for the past 3 years. I built relationships with most of the unhoused community, and I can tell you this, not once have I met someone that does not want housing. Everyone wants stability, dignity, and safety. Housing is a human right, and until we treat it as such, it is unjust to punish people for surviving without one. These ordinances don't just harm the unhoused, they harm the entire community. They waste taxpayer money on sweeps, police hours, and jail cells when decades of evidence shows they do not work. So I ask you, will Seaside be a city of leadership, or will it follow the failed, inhumane path being passed down from Washington? Will you repeal these ordinances? Thank you.
Carla Lobo, you now have the floor to make.
Thank you. I'm speaking today in opposition to the ordinance amendments. This proposal may appear to improve safety and cleanliness, but in reality, it targets and criminalizes the daily survival of our unhoused neighbors. Once the city makes it illegal, it will be illegal, punishing people for existing in public spaces. That is not safety. That is discrimination against those that cannot, and against who can and cannot use our parks and sidewalks. We cannot ignore the 2024 U.S. Supreme Court reversal on homeless protections. That decision already weakened the constitutional guardrails for our unhoused individuals. And now cities like ours are rushing to fill in the gaps with laws that push people further into crises. At the same time, California law is shifting to strengthen protections for unhoused residents, recognizing that criminalization is not a solution. These amendments walk a very fine legal line, risking costly litigation while placing vulnerable people at even greater risk. Meanwhile, state leaders are moving in a different direction. Labeling tents, clothing, medication, or documents as trash is dehumanizing. Seizing them without due process is not only legally questionable, but morally indefensible. Let's call it what it is: the doctorship of property, a modern play out of the 13th Amendment's loophole punishing poverty itself. Equity means recognizing that people didn't choose to be homeless. They are responding to trauma, disability, systemic failure. These ordinances treat homelessness as a crime instead of a public health emergency. Just because something is partially legal doesn't make it right. If we lead with compassion, we would invest in outreach, shelter expansion, volunteer storage, hygiene access, and supportive services, solutions that actually work. So I ask you, where are people supposed to go? Where should they store their belongings? Until those questions are answered with dignity, these amendments will only deepen inequities, invite litigation, and compromise our values. I urge you to table or significantly revise this ordinance and align with California's more human path forward. I yield the rest of my time.
Daryl Shote, Seaside resident. I stand in support of this ordinance. And why? Because every city seems to have a ordinance, something like this. But guess what every city's doing? Loading them up into their cars and dropping them on our doorway. This is just a tool. I do trust our police department will be very curious and mindful and hopefully just be able to speak to someone that is doing wrong. Because I believe me, on the corner of Del Monte and Fremont, every day I go by there. That's my way home. And I asked that guy, look, man, I can't give you no money as long as you keep throwing all your trash on that ground. Now, you know, some of them just does not respect any type of law. And it has nothing to do with them being homeless. It has nothing to them just being who they are. They just don't care. So we got to have a tool in the books. I think this is a great tool. I think we need to use it.
Okay, good evening, Seaside. This is Eloise Shim. I don't live in Seaside anymore, but I used to. And I had to live in a hotel in Seaside when I lived there. I also lived in a Airstream. And all that time, I had to have a storage. I had to pay for a storage facility. Now in Salinas, they have greatly expanded near Chinatown the storage facility. There's like millions of storage units there. So people who are homeless, they can put their stuff in a storage unit. they don't have to put it in public spaces. So I do support this ordinance for Seaside, because otherwise you're going to have homeless drug addicts on fentanyl like they have in San Francisco, like they have in Los Angeles, with their dogs and all of that coming onto the property of private citizens. And that is a health issue. It's a very bad health issue. Plus, it's a safety issue to have people like that. And I mean, I'm not looking down my nose on people who are homeless. I've been homeless myself. But, you have to use your head and maneuver your homelessness so that you're not stepping on the toes of the community and making the community a hellscape. So I think Seaside has to go along with what all the other California cities are going along with, and in Washington, D.C. and every place else, to get the people off the street.
Wes White, Salinas Monterey County Homeless Union, also a member of the LEAD committee, which is part of the continuum of care for Monterey and San Benito counties. Checking in because this ordinance is certainly regressive. It is certainly going to put a lot more people in harm's way. If you say all the community, you mean everyone who can afford to pay rent. And if you cannot afford to pay rent, then what's going to happen to you is we're going to take everything you have on a daily basis every time we see you. So keep going. And that whole attitude is, I mean, they're not homeless. They have a home. They have a home until you take it from them. They are addressless. What they need is like 400 square feet in a structure. That'd be 20 feet by 20 feet somewhere, anywhere. Public property, private property, it don't matter. It can be lined up. It's just a matter of respect. It's almost like you've shunned these permanent lepers from the church. And they haven't really done anything to really sin against you. Yet here they are to be nomads indefinitely. Monterey City just passed ordinance to haul away most people's vehicles and keep moving people along. Well, of course, they're coming to you. You're not trying to stop Monterey City from driving their problem to be your problem, which actually Monterey County has an encampment resolution policy that encourages jurisdictions not to do that. And what you're doing is the same thing. You're going to push your problem onto other jurisdictions, more likely the state and county jurisdictions, because they're the most easiest process of elimination to go. From what I noticed earlier in the year, folks would have to leave Seaside during the day and stay in San City until the night, which they weren't allowed to be there at night. So they better get back to Seaside. So these sundown laws are still happening on a daily basis. And we haven't really far removed ourselves from any kind of open discrimination as of yet. If you ain't got no money, that's the way we're going to discriminate against you. And we're looking to grab people as much money as we can, because gentrification is our business. Public service is meant for private gain. And that's been shown through this ordinance and how you've been doing business. You're going to align yourself with Newsom and the Supreme Court that says, oh, we're not responsible for you. We don't need to provide you housing. You just need to get out. And by the way, we're taking everything you got, and we're going to call you the criminal of the rest of your life. If you ain't going to give us money by way of rent, then we're going to make money off you by criminalizing people. We need to stop the sweeps. You need to give people an address. That's a real problem. It seems like the problem is more important to you than the actual solutions.
I was going to report at the councilmember reports, but today I spent, we all serve on subcommittees throughout regionally, and today I spent 2 hours with CHS, which is Community Human Services. And this is all we talk about, is helping people that are less fortunate and helping people get back on their feet. And this city does a lot. This city has multiple shelters. We have on Elm, we have a shelter. On Noche Buena, we have a shelter. This city steps up to the plate when it comes to this issue. And we put our money where our mouth is, and we are doing more than other cities. That was all my comments. Thank you, Mr. Mayor.
Thank you. What is the will of the council?
I motion to approve item 9B.
Second.
It's been properly moved in second. Are there questions or, on the question, any comments? I'll be quick if there's not. You have any? I'll be quick. I want to thank Councilman Miller for laying it out. We do a lot in the city of Seaside. We do a lot. Could we do more? I guess we could, right? But it's a balancing act with the resources and what we do as relates to the other responsibilities that we have. But we have a handful of shelters. We have city staff dedicated, at least 60% of their time to help homeless people find resources. Our family and community service team, that's really what they do if they're not on a crisis. That's a lot of time spent with that, case management. And that's out of our general fund. The resources for people without an address, and I think Mr. White made some good points. People without an address, the money that's for that stops at the county and here, the tri-county area, and then it comes back down through nonprofits that say they serve people that don't have addresses. But this is not to hurt or punish. I don't think it's regressive. I think we all understand what the word means, but someone said earlier about, I don't think the day-to-day implementation of this by the city manager is all of a sudden is going to be so harsh that this is harsh. So I got faith in him, and I got faith in the police department. I got faith in our public works. But I think we all can give examples, and I just want to give one or two. Someone standing in the median is a dangerous situation for everybody that drives by there, right? And so we have to think about that. And then today, just riding around, it was someone that doesn't have a proper address, and they were sprawled out, blocking the whole sidewalk. And at that point where they were at, you couldn't walk around on the grass because they had a flower bed on this side, and on the other side, it was their car, that was parked right up against the curb. So you would have to walk up and ask them to move out the way to pass by. Right. And so I'm sure they probably would have did that, but I know better than anyone else how it is, how tough it is. But this seems like a balanced approach to me by the city of Seaside. We are not stepping away from our care and our compassion for those that don't have a proper address. And my last point is, someone mentioned earlier about, it was what we did was wrong or what we did was bad when we had COVID and people were at the Roberts Lake area. And then once that died down, so to speak, we had those people move on. What they left out is we had them move to Colonel Durham with electricity and hot water for several more months. And so when you talk about the city of Seaside, we always step up, and we will continue to step up. And I have faith in our staff, city manager and his people, that this is not some type of way to criminalize people that don't have a proper address. But if we're going to be neighbors, then everybody needs to be a neighbor. And if you don't have a proper address, that doesn't mean you get to be a bad neighbor by leaving trash on the sidewalk or on the curb. And I know everybody doesn't do that. So I'm not going to lump everybody together. And I would ask everybody, don't lump this city council together as though somehow we're violating somebody's First Amendment rights. And then I can just about guarantee the city attorney is not letting us violate anybody's due process. I can guarantee you that. So it's good to hear those questions and it's good to hear those concerns, but if you read this document, this is not used to punish people. This is used to clarify things, and I'm supportive of it. And so I would ask the clerk to call the roll.
Council and Agency Member Miller. Council and Agency Member Burks.
Aye.
Council and Agency Member Garcia Arizola.
Aye.
Mayor Pro Tem and Vice Chair Pacheco. Mayor and Chair Oglesby.
Aye.
Your motion passes unanimously.